Good afternoon and welcome everyone. Today is Thursday, January 21st, 2021, and this is the time and place for the hearing examiner's proceeding for docket number 2021-003, cause number 475-03. In the matter of the request for agency action of CH4-Finley Operating LLC for an order authorizing the drilling of the proposed MB Tribal 223 South, 42 East, H1UB horizontal well to be located in the east half of Section 23 and the east half and the northeast corridor of Section 26, Township 4 South, Range 2 East, Uinta Special Meridian, Uinta County, Utah. My name is John Rogers. I'm an environmental manager with the Utah Division of Oil, Gas, and Mining, and I've been appointed by the Board of Oil, Gas, and Mining as the hearing examiner in this matter. We are holding this hearing virtually because of the restrictions placed by COVID-19 pandemic. I wish to thank the division staff, legal counsel, petitioners, and department technical staff for allowing this proceeding to go forth remotely. We now have completed several of these hearings remotely, and the procedure is working quite well. We'll now take appearance of counsel. For the petitioner,
Fred McDonald of counsel with Lear & Lear on behalf of CH4-Finley Operating LLC.
thank you. Division,
This is Charles Lyons with the Utah Attorney General's Office here on behalf of the Division of Oil, Gas, and Mining.
and my counsel is Haley Souza of the Attorney General's Office. We'll now proceed to Mr. McDonald with his opening remarks.
Thank you, Mr. Hearing Examiner. Today, testifying on behalf of the petitioner are Mr. Zachary Archer, who is the Senior Landman of CH4 Energy Finley, Utah LLC, and Mr. Shay Atkins, who is the Geology Manager of Finley Resources, Inc. I want to point out that it is obvious by the name of the petitioner, these two companies are the members of the petitioner, and there are shared duties with their personnel. And consequently, that's the difference there in the names. At this time, I would ask that they be sworn in.
Okay. I should have checked in with Michelle. Are you hearing us all right?
I am. I'm ready to swear them in. Will you raise your right hands, please? You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Gentlemen, you may want to unmute your phone. Michael, could you unmute them?
Were they
I
able?
cannot unmute them.
Okay, there we go.
Okay.
Shall I re-swear them? Because I didn't.
Did
Did they
they?
even hear me?
Did you hear the swearing in? I'm not sure.
Yes, we did. Can y'all hear us on
I'm getting some feedback, and so must everyone else.
Yes, I am.
Is there any way we can unmute the phone?
The phone is unmuted.
Okay.
Why don't we
you're not-
start over again, Michelle?
Well, next time I make it back, I'll.
I'm sorry, guys. The phone is muted on our side still.
Okay, if you could unmute that, Michael, then that'll allow them to talk through the phone.
That one was like.
I would love to, but I don't have the ability to unmute on our side, just to mute.
Okay.
Zach, can you call back in on that conference phone?
Just a taste. This is not next. My texture is not. It's more than
We're gonna. There we go.
It's just like squeezing toothpaste out of a tube.
I think with a call this size, when you call in on the phone, it's going to automatically mute you, but the trick is to push *6, if I remember from when I've done it.
Okay, that should work. It's showing that you're on there. Can you guys hear us okay?
Yes, we can. Can you hear us?
There we go. Okay, Michelle, do your thing.
Okay. Will you raise your right hands again? You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, we did, ma'am.
Okay.
All right, thank you, Mr. Hearing Examiner. The resumes of the witnesses were collectively submitted as Exhibit A. If asked, each of them would confirm the information reflected in the resume is true and correct. Mr. Archer will be a fact witness only. Mr. Atkins has been previously recognized as an expert in geology by the board on several occasions, the last being in cause number 600-01 in 2020. Presuming the division has no objections, I would request that Mr. Atkins be recognized as an expert in geology for purposes of this hearing.
Mr. Lyons, what's your feeling on that?
The division doesn't have any objections.
Okay, we'll accept him as an expert.
Thank you. I also want to confirm that everyone has received the Exhibit L that was filed last Friday and the supplements to Exhibit E and Z.
I have. Has everyone else received those?
I believe we have, yes.
Okay.
Okay, thank you, Fred.
Just as a reminder, the supplement to Exhibit E was filed yesterday at the request of the hearing examiner and the division's counsel. I did not have time to file a formal motion for leave to file that out of time, but I will make that motion right now if that's acceptable.
Yes, that will be, Fred.
Thank you. Also, just to confirm, I will be moving for admission of all those exhibits at the end of our presentation, Chief.
Okay, thank you.
Okay, today CH4-Finley Operating is seeking approval to drill the MB Tribal 23S42E 1HUB well, which is a sectional and 1/2 long horizontal well within an area that's currently unspaced. The well is going to target oil production from the Uteland Butte member of the Lower Green River Formation. The primary purpose, as you will hear, for the drilling of this well is to determine the efficacy, both from a production and economic standpoint, of such a well in lieu of continuing vertical well development, which has primarily occurred in this area to date. As will be discussed, CH4-Finley will maintain a conservative 660-foot setback from boundaries. Current regulations require, in the absence of a board spacing order, horizontal wells to be drilled within one section only and with 660-foot setbacks from sectional boundaries and 1,320 feet setbacks from vertical wells producing in the same formation. In other words, a horizontal well may not cross sectional lines, arguably absent an exception location approval. True and correct copies of Utah Administrative Code rules are 649-3-2 and 649-3-3, which are the applicable regulations, were collectively submitted as Exhibit B. CH4-Finley has secured some, but not all, of what would be the requisite written consents to the drilling of the proposed well from the effective owners to allow an administrative exception location approval from the division under R649-3-3. Regardless, the division has previously advocated to the board that, under the current regulations, it does not have the authority to grant an administrative exception location approval for a horizontal well crossing a sectional boundary. As the hearing examiner is aware, at the directive of the board, the division is currently in the rulemaking process to revise the horizontal well regulations, including resolution of the issue of horizontal wells crossing sectional boundaries. However, that process has been put on hold until at least July of 2021 due to the pandemic and other pressing rulemaking. As a consequence, CH4-Finley's only option was to file the request seeking authorization directly from the board to drill the well. The board has jurisdiction over this matter pursuant to Utah Code annotated section 40-6-5 subsection 3B and Utah Administrative Code Rule R649-3-3. Notice was sent via certified mail, return receipt requested to all owners, as that term is defined by statute and regulation, and operators within sections 23 and 26, and in wells within 1,320 feet of the proposed wellbore pad. These mailings were sent to the parties at their last addresses of record disclosed by the relevant state and federal agency records, the realty records of Uena County, and the internal land records of CH4-Finley, Utah LLC, and Finley Resources, Inc. The record will also reflect that notice was duly published on January 2nd in the Deseret News, on January 3rd in the Salt Lake Tribune, and on January 6th in the Uena Basin Standard and the Vernal Express. By board order entered December 29th, 2020, and due to the COVID-19 pandemic, this matter was referred to the hearing examiner for virtual hearing today pursuant to Utah Administrative Code Rule R641-113-100 and executive order of then Governor Herbert. The division elected not to file a staff memorandum in this cause, and no other objections or responses were received. With that, I'll commence my examination of Mr. Archer. Mr. Archer, would you please state your name and business address for the record?
Zachary Archer, 5128 Apache Plume Road, Fort Worth, Texas, 76109.
And what is your current position?
I'm a senior landman with supervision over the area at hand.
All right. Would you please provide for the record, the corporate and bonding status of CH4-Finley Operating LLC?
CH4-Finley is a Delaware limited liability corporation in good standing with its principal place of business in Fort Worth, Texas. We are duly authorized to conduct business in the state of Utah, fully bonded with all relevant state and Utah federal agencies.
All right. Is everybody seeing the PowerPoint presentation?
Yes.
Okay. Mr. Archer, I'm now going to show you what have been marked as exhibits C through F and L. Excuse me, L is not on the PowerPoint, but it is in your book that you should have in front of you. Do you recognize these exhibits?
Yes, sir.
Were they prepared by you or CH4-Finley personnel with your input and review?
Yes, sir.
Okay, turning your attention now to Exhibit C, which is shown on the PowerPoint. Would you please outline to the hearing examiner and the council what it represents?
This is a map depicting the proposed area for the requested exception location. It's about approximately 20 miles southeast of Fort Duchesne in Uintah County.
Okay, turning your attention now to Exhibit D. Please explain what this represents.
This is the outline of the proposed exception location area being section 23 and 26. The plat shows 8 existing vertical wells in south half of section 26. Also the existing vertical wells in the southeast of section 14, and as well as the southwest of the northwest of section 25. All of the vertical wells that I just referenced are operated by Finley Resources.
Okay, and just to clarify for the record, the 8 existing wells are in the south half of section 26, correct?
Yes, sir.
Okay. Now, turning your attention to Exhibit E as supplemented, starting with the first page, would you please explain what this represents?
This represents the mineral ownership of the area that we're requesting the exception location. As you can see in gray, that is tribal ownership, and everything in gold is fee ownership, fee minerals.
And what is the gray area leased to CH4?
Yes, sir. The gray area is leased to CH4-Finley by virtue of the exploration and development agreement with the Ute Indian tribe.
Okay, and the oddball rectangles are shown. Those are mining claims, aren't they? Patented mining claims? Is that why they're strange?
Yes, sir.
Okay. All right. Is CH4-Finley the duly designated operator of the lessees in these areas?
Yes, sir.
Okay. We'd like to clarify for the record, there was an error in paragraph 2 of the request. Mr. Archer, would you please address that?
Sorry, yes, we need to request that CH4-Finley is going to operate all of the horizontal and vertical wells on behalf of the entity, on behalf of Finley Resources, and then Finley Resources will continue to operate the existing vertical wells.
And just for reference, that paragraph 2 said that CH4 would do a horizontal operations and Finley would continue to do all vertical. So we wanted to clarify that Finley is only going to continue to operate the existing vertical wells. Okay, now turning your attention to the supplement to Exhibit E, would you please address what this represents?
Yes, so this is the mineral ownership broken out to show you what has been leased, what is undivided, what's undivided and partially leased. So everything in yellow in section 23 and 26 is 100% leased and or owned by CH4-Finley, Finley Resources, and Grasslands Energy. The only parts that are not 100% leased are the red and blue hatched areas. I'm going to start with the red hatched area. That's lots 5 and 12 of section 23. You have 71.73% is leased or owned by CH4-Finley, Finley Resources, or Grasslands Energy. 28.27 is currently unleased. As for lots 7 and 8 down in section 26, that's 62.5% leased or owned by CH4-Finley, Finley Resources, and Grasslands Energy, and 37.5% unleased.
And just to clarify again, Grassland Energy has appointed CH4-Finley Operating LLC as its operator. Is that correct?
Correct.
Okay. Were any efforts made to contact these unleased owners?
Yes, sir.
And what were those efforts?
We have sent them requests. We've made phone calls, sent them lease offers, and we're currently in negotiation with several of them, but we have not executed leases with those parties at the moment.
And again, the record will reflect that none of those parties have made an appearance or filed an objection in this matter. Also, these exhibits also generally reflect the proposed wellbore path. Is that correct?
Yes, sir.
And for the hearing examiner and the council, we'll get into detail on that wellbore path in Mr. Atkins' testimony. Okay, now, Mr. Archer, I'm going to direct your attention to Exhibit L. There is not a PowerPoint for this. These documents, could you please tell the hearing examiner and staff what they are?
These are copies of 2 letters executed by both Finley Production Company and Grasslands Energy, reflecting their written consent to the proposed drilling and operations of the well in question.
Okay, now turning your attention to Exhibit F, would you please explain to the hearing examiner and council what this represents?
This represents the notification areas that we sent for this exception location. As you can see, we notified everything within section 23 and the north half of section 26, as well as the south half of 26, the southwest of the northwest of section 25. And I need to correct that in section 14, we only notified the south half of the southeast of 14, because the south half of the southwest was outside the 1,320-foot marker, and so we did not notify those individuals there.
Okay, and we will submit a corrected exhibit reflecting that. Again, the people in the south half of 26, the quarter and 25, and the south half of the southeast and 14, why were those parties notified?
Because they were within 1,320 feet of the proposed wellbore.
With the wells that were within 1,320 feet, right?
Yes, sir.
Okay, now I'm going to direct your attention to the certificate and the supplemental certificates of mailing. You should have those in your packet. These are pleadings that were prepared by my office with input from you. Do you recognize the names and the addresses on those certificates?
Yes, sir.
Who are those parties?
Those are parties that are subject to the exception location, or would be affected by the exception location request.
So those would be the owners in the notifications shown on Exhibit F?
Yes, sir.
Okay. And how were those names and addresses compiled?
They were compiled via CH4 Finley internal records, Finley Resources internal records, and under parties under my instruction with the county records, BIA, BLM, and associated records. Okay.
Exhibit Z is supplemented to constitute the true and correct copies of the return receipts received by my office for the mailing of the request. or the United States Postal Service inquiries we made if we did not get return receipts on that. With that, Mr. Hearing Examiner, that concludes my examination of Mr. Archer.
Okay. Mr. Lyons, does the division have questions for Mr. Archer?
Would it be okay to reserve questions for after hearing from Mr. Atkins as well, and maybe address both of them at the same time? That way we could maybe sort out who the best person is for those questions may be.
That's fine with us.
I see a frozen picture from Mr. Rogers. I don't know if he's having an issue with that. Okay.
I lost connection there. Can you hear me now?
Yes.
Yeah.
Okay, I'm not sure when that all happened, but I had a question for Mr. Lyons. Do you have questions for Mr. Archer?
Yes, and I asked if it might be better to just allow further testimony from Mr. Atkins, and that way if the division has questions, we could pose to them both. That way either one might be better suited to answer those questions. It may be easier to go that way.
Okay.
Is that okay?
That's fine. Okay, proceed, Fred.
Thank you. Mr. Atkins, would you please state your name and business address for the record?
Yeah, my name is Shay Atkins, business address of 5128 Apache Plume Road in Fort Worth, Texas.
All right, and what is your current position?
My current position is geology manager for both Finley Resources as well as CH4-Finley, with supervision over all of our assets in Utah.
All right, and just so we get it on the record, is Finley Resources Inc. in support of this request as well?
Yes, Finley Resources expresses support for this RAA.
Okay, now turning your attention to what have been marked as exhibits G through K. For this, do you recognize these exhibits?
Yes, sir.
Were they prepared by you or CH4-Finley personnel with your input and review?
Yes, they were.
Okay, turning your attention now to exhibit G, would you please explain what it represents?
So exhibit G represents the proposed well, being the green arrow, with the surrounding lands in the south half of section 26. You can see the green dots represent 8 existing vertical producing wells, which is a fully developed area, the south half of the section 26. The red outline inside of the proposed lands represents the proposed setback, which matches the field-wide horizontal spacing rules of 660 foot. And this area is currently undeveloped. And based on these setbacks, the proposed well would have a completed lateral length of approximately 6,358 feet.
And what is the idea behind?
Oops, oops. I keep would have a completed lateral length of approximately, and then I didn't catch the number. 6,000 and
6,358.
thank you.
Okay. And what is the driving force, or why does CH4 and Finley want to drill this well?
The purpose of drilling this well is really to determine if horizontal drilling is not only effective in this area, but is also in combination with vertical drilling, the most efficient and prudent way to develop these resources as compared to further developing these lands vertically. So prior to continuing to infill drill vertically, then we would go ahead and drill this horizontal well prior to making that decision.
All right, turning your attention now to Exhibit H, and for the hearing examiner and counsel, I tried to give you a heads up. If you had the hard copy of this, it comes out much clearer than it does on the PowerPoint, and I would ask you to refer to the hard copy. Okay, Mr. Atkins, could you please explain to the hearing examiner and the council what this represents?
Yeah, sorry, I apologize. It's a little bit busy, but so this represents the surface location of the MB Tribal 23S 42E H1 UB that would be drilled from a surface location of 214 feet from the north line of section 23 and 861 feet from the east line of section 23, with a first take point of 660 feet from the north line and 710 feet from the east line of section 23. It'll traverse the east half of the northeast quarter and lots 5 and 12 of section 23, as well as lots 1 and 2 of section 26, with the last take point at 1,806 feet from the north line of section 26 and 709 feet from the east line, with a terminus that is 1,856 feet from the north line and 710 feet from the east line. This also depicts offset wells to the north, east, and south, being the gooseneck 14-6B-4-2, the bar F 25-4A-4-2, the bar F 25-5A-4-2, and the Deep Creek 9-26-4-2, with the red circles around each vertical well surrounding this track represents 1,320 foot offset from these producing wells.
And if you go to Exhibit I, this is the blow up so that they could see those offsetting wells a little better. Is that correct?
That is correct. So on the left side of the screen, you can see the black dot in the northeast part of section 23 represents the surface hole. There's a blue call out for the first take point of the horizontal well with a blue dashed line representing the wellbore, and where this is, it sits in relation to the gooseneck 14-16B, as well as the red circle with the 1,320 foot setback. On the right side of the screen is a zoom in of the toe section of the proposed well with the corresponding offset vertical wells and their 1,320 foot setbacks, or offsets, I should say.
Okay, and I believe Mr. Archer testified, but could you confirm, does Finley Resources operate all of these offsetting vertical wells?
Yes, sir, Finley Resources does.
Okay, and in your opinion, will there be any communication anticipated from the horizontal well with any of these vertical wells?
No, sir, in my expert opinion, there will be no communication between these wells.
And is that based on your experience with horizontal drilling in the basin and what the potential fracture half lengths would be?
Yes, sir, it is.
All right. Now turning your attention to Exhibit J, would you please explain what this represents?
Exhibit J is a structure contour map on the top of the Uteland Butte member of the lower Green River Formation. You can see the red outline of the proposed lands toward the southeast portion of the map, with the downward or southern direction representing up dip or shallower, and the northern or upward direction representing down dip or deeper into the basin. And so I'd like to point out the position of the proposed lands being in the southern portion, and therefore shallower than other areas historically that have been drilled horizontally.
And what's the significance of that with respect to your this proposed test well for purposes of this hearing?
Yeah, the significance of that is mechanical risk, and for not only drilling to reach the full 2 miles, compared to other horizontal wells, but also completions and effectively producing the reservoir.
Okay, now turning your attention to Exhibit K, would you please outline what this represents?
Yeah, Exhibit K is a cross-section of open hole logs through this area across the proposed lands, with starting on the left side of the cross-section being to the north and the right side of the cross-section being to the south, as represented on the map to the left. You can see outlined in tan is the Lower Green River Formation, being approximately 1,850 feet in thickness in this area, with the Uteland Butte member of the Lower Green River at the very basal portion of this section. I'd also like to point out on the right side that in this area, this entire Lower Green River section has been produced vertically historically, and the Uteland Butte member is a continuous carbonate zone across the basal part of this formation, and therefore, because of its continuous nature, represents a theoretically we think is a good horizontal target.
Right. In your expert opinion, then, does the geology of this area require further study to determine the efficacy of the development utilizing less than 2-mile long horizontal wells, or whether development should instead continue with vertical wells?
Yes, sir, it does.
All right, Mr. Hearing Examiner, that concludes my examination, Mr. Atkins.
Okay, thank you. At this time, we'll turn to the division. Mr. Lyons.
Sure, thank you.
I'm sorry, can I interrupt and make one request? The witnesses are just barely out of camera. And so when they speak, can they just say their name first so I know who's talking?
Yes, ma'am. Sure can.
Okay.
Thank you.
Yes, Michelle, just so you know, Mr. Archer is on the left and Mr. Atkins is on the right.
Okay, so this question may be for Mr. Archer. Was written consent obtained from all locatable owners within the fee tract?
Within the fee tracts, within the DSU, we did not get consent from all of them. We got consent from the other working interest owners within those tracts.
Okay. And so this question perhaps maybe, I don't know, this is why I wanted to ask, perhaps asking questions once we had both gentlemen a chance to speak. But with this, going through 1.5 sections, 23 and 26, if approved, how would this mean for the future of this well as far as spacing is concerned? Would that be 23 and 26 completely, or would it be 1.5 sections?
As it stands right now, we'd go for 960, which is a 1.5 sections, especially since the southern half of section 26 is drilled up on vertical production or drilled up on vertical development. So we would start with 960s unless something else, unless something else showed us differently and we needed to develop it on 1280s versus 960s.
Right.
I'm sorry, was that Mr. Archer?
Yes, ma'am.
Okay.
And this is Mr. Atkins. I would like to add to that a little bit as well, that depending on the results of this well, we fully expect, if successful, to come back before the board to request a spacing for a larger area across this area in order to continue going forward with with 1.5 mile horizontal wells, as well as vertical drilling.
Okay, and I think, part of the concern is there, in your opinion, is there any potential for waste that may occur in that southern half of section 26?
No, in my opinion, the southern half of section 26 is fully developed, and therefore no waste is occurring from the vertical development.
That was Mr. Atkins. Michelle.
Okay. Another question, it may be easier, Mr. Rogers, if it's okay, to allow Dustin Doucette or Dane Doucette to pose any questions to the witnesses, if that's okay with you, as they're participating in this as well.
Sure. That would be fine, Mr. Lyons.
Okay, and I know Dustin or Dan, you guys may have a few questions. Do you have questions that you'd like to ask either of the two witnesses at this time?
This is Dustin. I've got a couple. If I can go ahead right now, that'd be fine.
That'll be fine.
Okay, so Dustin Doucette for the division. Probably on the supplemental exhibit E that we're on right now is probably a good spot. Just kind of following up on Charles' question as far as spacing is concerned, how is this well going to share in production currently drilled before you get it spaced? I mean, if you drill it, how will you share it before you go back before the board and do spacing? Is that going to be shared on a lease basis? And which leases would share?
Well, since it's undivided ownership amongst all those tracks, I would say we'd share it on a 960 basis.
Okay, so basically everything within that 960 would share, would be your plan on how that would share?
Correct.
Okay. And just the differences between the original exhibit E, which seemed to show the wellbore going through the center of some of those tracks, and the supplemental exhibit E showing going to maybe the left-hand side of that track. Is that just a depiction? Are those separate fee leases to where there's one maybe on the west half of that hatched area there on this exhibit, supplemental exhibit E?
No, I think it's just the way it's drawn into that exhibit. It's the only difference in ownership is that lot 5 and 12. So it doesn't slide over to the other side of the well, if that's what you're asking.
Yeah, I think that's basically what I was getting at. Is that basically the original exhibit E? Is that those are consistent leases, I guess, where those blocks are at? One lease that is undivided interest within those leases?
See, there's several leases under 5 and 12 that are undivided, and then there's one lease in the northeast of 23.
And which ones are 5 and 12 then?
Lot 5 and 12 are basically that east half of the southeast of 23.
Dustin, if I can help you with this is probably more accurate depiction. In supplemental exhibit E, the red hatch actually should come over here a little bit more. 5 and 12 make up the south half of the southeast of 23. And the wellbore will go through the middle of that.
Right. This is Mr. Atkins. Exhibit I depicts this as well, and it has a call out for lot 5. The surveyed plat has a call out for lot 5 and also shows the wellbore path.
Right here is lot 5 if you look at the PowerPoint right now. And lot 12 is directly below it.
Right, and this is a surveyed plat from a surveyor in the basin.
So lot 5 and lot 12 are separate leases, is that what you said? And then the rest of it is a different lease?
So lot 5 and lot 12 it's undivided. There's multiple leases. It's just undivided ownership throughout that entire 5 and 12. The northeast of the northeast is a separate lease. It's its own fee owner up in the northeast of the northeast. And then the lot 7 and 8 of that wedge of 26 is same thing, undivided ownership. It's multiple leases. It's undivided.
Okay, but you're greater than 660 from those.
Correct.
Leases. Yeah.
Correct.
And so maybe this is a good exhibit for one other follow-up question I had on that mining claim lease, kind of in the center of section 26. I noticed that wasn't on that supplementary E either. Is that consistent throughout the Uteland Butte area, or is it a different horizon that lease is that lease covers. I'm talking about the MS 5520, I believe, is the lease I'm referencing.
No, the leases that are covering that area are all depths.
Okay. And so what is the owner? I don't think that was provided on that supplementary exhibit E. What is the ownership of that? You know offhand?
Of the mining claim?
Of the mining claim, yeah. Is it consistent with what's in the blue hatched area?
It's different. It's different. That's different mineral ownership, and that mining claim is 100% leased.
Okay.
Johnson, if I could help on Exhibit I, if you look at Exhibit I that's on the PowerPoint right now, the mining claims are leased. Lot 7 and 8. This is Lot 7 here, and Lot 8 is this little triangle down here below the mining claim. If that helps.
Yeah, I was just more interested, I think, in the mining claim itself.
Okay.
Especially down that 5520. You said that's 100% leased, and is that owned by Finley, or is that another party?
It's owned by CH4-Finley.
CH4-Finley. Okay.
I think can I make a call out? This is Mr. Atkins. I think the supplement to Exhibit E is to identify those leases that are not 100% leased by CH4-Finley, and the mining claims are 100% leased by CH4-Finley. So those were not highlighted or called out on Supplemental Exhibit E, whereas the original Exhibit E was a call out for all fee ownership and tribal ownership. And so if it's not called out on the Supplemental Exhibit E, then CH4-Finley has 100% leasehold.
Okay, yeah, that helps a lot. Yeah, that kind of answers the question I had. Thought I had another question, but I can't think of it right now. So I think I'll call it at that. Thanks.
Thanks, Dustin.
And I don't have any further questions. However, Dane Doucette might have a question. Dane, do you have any questions for the witnesses?
Yeah, this is Dane Doucette with the division. This might be more of a legal question than a witness question, but I just want to make sure we're all on the same page here. So 649-3-3 exception location, says that you have to have written consent from all owners within a 460-foot radius of the proposed well location. So I guess my question is, you said you didn't have written consent from all locatable owners, but are we saying that because this is an undivided interest and you do have the area lease, therefore you have the right, so basically all owners are accounted for? I guess I just want to make sure we're all on the same page, that we're meeting the requirements of the exception location.
Right, Dane, if I can answer that, the issue here is, is there any mineral trespass occurring here? And because of the ownership that's reflected here, that CH4-Finley, Finley Resources, and Grassland owns leases of the majority of the interest here. They're co-tenants with those unleased owners that haven't offered a written consent. And as a co-tenant, they have the right to drill there. They have to account for everybody. But also with getting the exception location, they were notified of this request and had the opportunity to object if they had any, and none of them filed any objections to it. So the legal answer is yes, they would have the right to do this. By the board's process, they've offered due process if they had an objection to it. And so the right to be able to drill it would be legal under the board's authority if they grant it.
Right. So, so we're saying they don't really need written consent as the rule requires because they've got the majority leased or whatever, and then protecting the other owners that are unleased. They could have. The rule says written consent, not notice, but since it's joint tenants or whatever, it's undivided interest. I'm just making sure they don't really need the written consent since they have a lease covering the whole area, correct?
Well, no, the written consent part goes to where the division can administratively grant an exception location without having to go to the board. There's situations where you just can't get written consent from everybody. So in those cases, you have to go directly to the board as opposed to the division be able to do it administratively. In other words, if they had gotten everybody's written consent here, they could have asked the division for an exception location. But as I mentioned in my opening remarks, the division has previously taken the position that the current regulations don't allow them to do that for a horizontal well that crosses section boundaries.
Right. Okay, thanks.
Mm-hmm.
I had one other question, John, if I could. That reminded me of the question I kind of had. I noticed on the supplemental exhibit Z that there were still like, I think, five parties waiting to receive delivery. And then maybe one that was awaiting pickup of that notice of this hearing. Was there I guess first question is there any update on the number that have been notified and beyond that? And is that an accurate number? And then beyond that, my question would be, have you had other attempts to contact these people prior to the notice of the hearing?
If I can address at least the mailing status situation, since it's affecting my office. We updated this on Tuesday. As far as the ones where it says, you know, it's in delivery status, all that, you're entirely reliant on the Postal Service. That's why we sent them certified mail to at least be able to track it. As far as somebody not picking it up, that's on their end. It was delivered to the last address of record. As far as the efforts of contacting anybody else, Mr. Archer, do you want to address that?
Yes, we have contacted, I mean, as far as the unleased interest within the tracks that are on this notice list, we're still in communication with those individuals. So we are actively trying to continue down the path with them. And the rest should be duly noticed as we provided in this, or at least they're either least interest under the other tracks, excuse me.
Okay, and we haven't received any objections that I'm aware of, is that correct?
That's correct.
Okay, thank you.
Mr. Lyon?
I think that, yeah, that would be everything from the division, Mr. Rogers. Thank you.
Okay. I have some questions here, and it might go back to what we were just discussing, but I want to get a firm handle on this. Within the pink area there, is that lot 5 and 12?
Yes, sir.
Okay. And is CH4-Finley a member of, has an undivided interest in both those lots?
Yes, sir.
Okay. So when we say that those 5 and 12 are 71% leased and 28% unleased, does that mean there's 28% of the people that cannot be found or have not responded, but yet you do have consent of these other undivided interest owners in those two lots?
Correct. So the 71.73% represents either CH4-Finley, Finley Resources, and Grasslands as to their percentage of the ownership under those undivided ownership under those tracts. We have their consent. The 28.27% of lots 5 and 12 are the unleased parties that, like I said earlier, we're actively working on leasing, but we have yet to secure the leases to date.
But these are all undivided interest owners, along with you in there.
Yes, sir.
Okay.
If I can also clarify, it's common ownership, common mineral ownership in lots 5 and 12.
Okay. And is the same situation down in the blue in the southwest corner?
Yes, sir.
Okay. So you plan to share on a 960 for everyone in here?
Yes,
Is that your
sir.
plan? And these unleased owners, will that money put into escrow and be held for them, their royalties? Or how are we going to work that out?
If we don't secure a lease, we'll have to look at the particular situation of the well, and we'll either carry them or we'll go to the forced pooling process, or we'll offer them the right to participate as well.
Okay. And forced pooling would go back to the date of first production?
Yes, sir.
Okay. So how many people does the 28% represent?
28 represents, let's see, under lots 5 and 12, you've got 2 owners.
So only 2 have not been leased then?
Yes, sir.
And how about in the blue section?
On the blue section, you've got 1, 2, 29.
Okay. So in my mind, you essentially contacted or at least leased with everyone that is at least one owner in this section, both the blue and the red.
Yes, sir.
Okay. All right, well, I'll turn it back to you, Mr. Lyons. Did the division have any presentation of a case or opinion on this?
No, we don't have a presentation. I do share the concerns and I guess the question that was provided by Dane Doucette, where the rule, this is the language of the rule, 649 3-3, requiring written consent from each owner. I know, Mr. McDonald, you had discussed that the co-tenancy issues and putting everybody on notice for due process, but I'm just wondering if that satisfies that language of that rule. That's the only comment that I would say at this point related to that. That's the one thing that seems to be a little up in the air to me, just based on the plain language of that rule.
Okay. Could we go offline for a little bit here, and I'd like to discuss that with my legal counsel?
Could I address that, Mr. Hearing Examiner?
Sure.
If you assume that you have to have the written consent of everybody for it to be approved, you could have a mineral interest owner at a 0.007% holding up the drilling of a well. And that's why the idea was you get the written consent from everybody. There would be no need to go to the board and have a hearing. The division can administratively grant that, recognizing that everybody's agreed to it. In the situation where you don't have everybody, you go to the hearing to allow the due process to go forward for those owners to come forward if they have a true objection to what's being done, as opposed to just being unresponsive. So in my opinion, the way that rule reads, you go to the board provides the due process to allow them the opportunity to make their case of why the well shouldn't be drilled if that's the case. And like I said, in this situation, you don't have anybody objecting, they were just unresponsive. And I've done this before, and this is the way we've done it in the past when you can't get full consent. So in my opinion, legally, you are in full compliance by going to the board and pursuing this process.
Okay. All right, thank you, Fred. I still would like to confer with Russell, so I'll give you a call, Haley, okay? speaking with Ms. Sosa. Michelle, are you there? Good. Mr. Lyons, did the division have any more else to comment, or I'm not sure where we left that?
No, the division doesn't have anything else.
Okay. As I looked through this, the concerns I had have pretty much been alleviated. First of all, is drilling cross-section lines. That, I think, prevents waste by allowing that. They own minerals on both sides, so I'm okay with that. As far as the distance from vertical wells, having a nearly 1320, our setback has been 660 for most of these horizontal drillings. And so I'm okay with that. As far as the mineral sharing, I'd like to give some time to Haley to explain my concern about where those royalty payments will go towards those who have not been found. So I'll turn the time over to Haley.
The question that Mr. Rogers asked was if the royalty payments from the production would be placed into escrow, and it wasn't clear based on your answer that that was something that was going to be happening. So I just wanted to point to 40-6-9, and that requires that any proceeds be placed into an interest-bearing escrow account if they can't be made to the royalty interest owner immediately, or within 180 days. So the division expects that any payments need to be put into an escrow account. They just can't be kept on the books or kept somewhere that's not in an interest-bearing account.
Okay.
And that alleviates the last of the concerns. I think, Mr. Rogers, was that the last of it?
Yes. Okay, thank you, Haley. So given that, I would conclude that we can grant this petition and put it before the board our next hearing. Fred, if you could drop the order on that with the caveat about the payments to these individuals that cannot be located.
Yes, we need some bookkeeping though. I need to get the exhibits admitted.
Oh yeah, we need to do that. Okay, go ahead, Fred.
Yeah, so I would move for admission of exhibits A through D, E is supplemented, F through L, and Z is supplemented.
Julianne, did you get that?
Yes, I did.
Okay. All right, for those, and anything else? Okay, well, thank you. What's that?
I was just going to say, in addressing your concern on what Ms. Souza said, the intention here is to see what the well does initially. And I believe Mr. Atkins testified that the idea would be to come back and seek spacing, which would also put that in that situation. So the idea is to seek spacing and then retroactively pool back to that date. And of course, they're aware of their requirements under the statute for suspension of proceeds. But I will make sure that that's in the order as well.
Okay. Well, I appreciate your time. We'll grant that. And if you could get that order, do you have a time frame on that, you think, Fred?
I'm going to work on it this afternoon and tomorrow, and hopefully have something to you by tomorrow afternoon, and for Haley and for Charles.
Okay, thank you. All right, appreciate your time, and we'll conclude this matter. Thank you for all those involved. We appreciate it.
And thank you, Mr. Rogers, and to the staff.
Yeah, thank you all very much.
Thank you.
Okay. Thank you, Shay and Zach.
Thank you. Thank you all.
Okay.